Now, I have another question because the Constitution grants us two different criminal jurisdictions, okay? One criminal jurisdiction is under the common law, and the other is under the criminal jurisdiction of admiralty or military tribunal venue from Article 1, Section 8, Clause 17 of the Constitution.
Can we come back to your case in a second? I got to do some other cases, and then I'll take the time to do all this with you.
Well, I need to know which of these two jurisdictions that you intend to try me. It's very important because they're done different ways. The rules of civil procedure are very different in a criminal jurisdiction, obviously for common law and a military.
No one's asking you, no. So we just need to show, were you able to cure your license with the DMV, or you don't know?
Your Honor, I need to get these other questions answered. I need to know what the jurisdiction is, and I need to know also who the injured party is. The nature and cause of this. I need to know who the injured party is.
Okay.
I need to know who's bringing the claim.
How about, okay, the state is. So here's the deal. Do you want to have a trial date? I can give you many trial different dates.
Now you notice his voice level rise. He's arguing. He's in dishonor. My point is, why are you challenging jurisdiction to the trier of fact? Your voice cannot be heard, regardless of the stenographer. Those records aren't always accurate, right? Let's just be real. But when you file process through the court, notice of court, affidavit, motion, affirmation, opposition, right? Things of that nature. That's on the record, the perpetual record of the case, the claim, right? It's documented at the dry dock center, hub, whatever, right? It's there. It's on the record, on and for the record, right? So why are you going to challenge anything to a non-Article 3 judge? And you didn't do it through paperwork. In my suggestion, in my opinion, and in my own personal experience, if I wanted to do that in theory, right, what would I do? I don't know. Maybe I would file a writ of quo warranto, demanding by what authority do you have, actor, and ask those same things. The Sixth Amendment grants me the right to know the nature and the cause of the action, right? It grants you the duty to disclose such, right? You took an oath to uphold the cause, blah, 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 blah. You can put all that in the writ of quo warranto, as well as demanding a certified copy of their oath of office, proving that they must adhere to the Constitution and the oath they took to uphold it, to hold that seat. Why is people not teaching this part? Because they do not know it. They're regurgitating videos like this one, and you think they're scholars. And they send y'all in there as the dummies to figure and find out how to get it done. It took decades to figure out a way how not to go into the court. Why would you go inside the court voluntarily? It makes no sense. You know a half and a piece of the game. It's obvious because you're allowing the judge to ask you discovery questions without objection. You're allowing the court to move without your objection or approval. And you didn't safeguard yourself before even going there. And you're going to challenge her as opposed to staying. As soon as they speak, I'm here in regards to that matter. Are you Michael? I'm here in regards to that matter. Oh, I'm looking for blah, blah, blah. I'm here in regards to that matter. I am Michael of the blah, blah, blah family. Oh, you can come up. Let the record reflect that before crossing the bar, I safeguard all my rights. All of them. I reserve all my rights, rather. They're going to let the record reflect before crossing the bar, reserve all my rights. Okay. Blah, 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 blah. This, on the third. The second they speak, in my opinion, what I do, and this isn't legal advice, objection, for the record, my honor, I filed blah, 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 blah. I have yet to receive a response from the court. And before this claim moves any further, that request, that demand must be met. And if not, they're in default. So you file default judgment, right? Is that not the proper way? So to have some of these videos say, look, it's got dismissed. No, it didn't. They adjourned it without you objecting to say, I don't consent to any adjournment. You guys got a lot of learning to do, and these dudes that are teaching y'all, that are charging y'all, it's a waste of time. You really have to know how to safeguard yourself, right? Are you redacting with brackets on your processing letters to the courts or everywhere, regardless of whatever? The area code and the zip code, rather. There's a lot of things you got to do. Are you signing things as opposed to autographing? There's a lot of things that people don't teach because they obviously don't know it, and it just sounds good, and people just go with the flow. And they'll flex like they thought they won. Then why are you going back to the court? They gave me a warrant in the mail. Is it a valid warrant? Because if they didn't have the jurisdiction you're claiming, it wouldn't be valid, right? So jurisdiction is not as easy as people think it is. You have to know how to stand in your square in a venue when you're even in the venue. But you got to know how not to even go in there. That's the Georgia shopper. That's foolish. It's a waste of time. Yeah, you can win if you know what you got to do, but you're talking about motions, affirmation oppositions, reply to affirmation oppositions, etc., appeals, Supreme Court, if they want to play the game, because nobody's going to sit down and say you're right, because the masses will know, and the attorneys that work in there in conjunction with the judges that get 18% of everything that comes across their desks through those transactions, they lose money. That's what it's about. So you can win and not know it, but when you talk too much, you bring yourself back in there and you open doors. One word, defendant. You agree to be that jurisdiction, so no matter what you submitted and filed. Do you understand? Jurisdiction. You walk off thinking you won. They say, "Oh yeah, can you come back here real quick?" And you walk back under their jurisdiction. Everything it's out the window. Have y'all ever done that? Judge say, "Come back." You walk right out the court. I have. Keep walking because you believe in what you believe in. Be careful.